I'm going to spend just a few minutes talking to you about what documents are included in your living trust estate plan. We get this question very often, and what people ask us is, well, if I create a living trust, am I just creating a living trust, or are there other documents? And I want to just quickly walk you through all the documents that you'll be signing if you create a revocable living trust estate plan. The first document that you'll sign will be a revocable trust agreement. That's the trust document that really defines the whole trust arrangement. This is how the trust is created, and this is where you name the trustees of the trust, the successor trustees of the trust. This is also where you answer the question, who gets what, and when do they get it, and how do they get it, and all of those things that we build into a trust. So this is probably, of all the documents, the document that is the most lengthy and comprehensive. Quite often when you are in the process of transferring assets to your trust, or doing what we call funding your trust, the bank or the brokerage firm will ask you for a copy of the trust, and when you actually take it to them, they see that it's a fairly lengthy document, and the response we usually get is, well, gosh, I don't think I really need all that. All I want to know is just certain specific things, and those things are actually the things that we've identified in advance, and we put into a document called a certificate of trust, and that document is about 2 pages long. So we also create one of those, and what we found is that about 95% of the time, anytime anybody asks you for a copy of your trust, what they really want is the certificate of trust. That is the 2-page document, not the bigger revocable living trust agreement. But we also create what's called a pour-over will, and the reason we do that is because your trust, your living trust, only controls the assets that are in it. So when you die, if you own assets that you never got around to putting in the trust, and that happens sometimes because people go buy things and forget to title them in the trust, then that means that those assets that are not in the trust, there's got to be a plan for where they go. And so we create for the client a will that we call a pour-over will that says, when I die, all the assets that are not in my trust on the date of my death, I hereby will to my trust. And that's why we call it a pour-over. You just imagine pouring coffee out of the coffee pot into the cup. The assets are being poured over from your probate estate into your living trust. And it's true that the assets that pass through that pour-over will do have to go through the probate court process. But after they do go through the probate court process, those assets do end up in your living trust and passing to your heirs as if they had been in the trust from the beginning. Now, every client we have has some assets that we just can't put into a living trust, or for reasons of convenience we choose not to put into a trust. For example, here in Arkansas, we don't make a practice of transferring automobile titles to a living trust because it's so easy through the Revenue Department to do an affidavit. It's just not, it's so easy to transfer an automobile at death. It's not worth the trouble and inconvenience to go transfer the title into your living trust. But you have things, we have clients that have things like IRA accounts, 401k accounts, 401(b) accounts, certain kinds of annuities where we can't, for tax reasons, transfer the asset into the trust. And so that means that if that client becomes incapacitated, we have to have a legal tool to manage that asset during the period of time the client is incapacitated. And that could be a day or two, or it could be months or years. And so that legal device is what we call a general durable power of attorney. And in that general durable power of attorney, what we will do is we will name an agent or a sequence of agents who are the individuals or the institutions who have the authority to manage those non-trust assets for the benefit of their owner during the period of time that the owner of that asset is incapacitated. Now, it's our practice to always, and I'm going to say always here because I can't remember a time when we didn't do it this way, to always name as the agent of the general durable power of attorney the same persons that we named as the successor trustees in the client's living trust. And I like to do it that way because that way I know that there's never going to be a conflict between my trustee and my agent. What it means is that my trustee may have more than one legal cap to wear, and they may have to pull out a different legal document to handle an asset, but it's always going to be the same person in that position. Then we have to get into the whole business of who's going to make our health care decisions for us if we can. And quite often, what our clients tell us is the persons that I've chosen to manage my property are not the same people I want taking care of me. It's a whole different skill set. It's a whole different attitude that people bring to the table. Sometimes we have clients that have children that are very financially responsible, but they don't feel like those children are necessarily going to be the most caring, considerate, and compassionate with respect to healthcare issues. And so we name different people to serve as agents under a healthcare durable power of attorney. And we also will create, as part of that packet of healthcare documents, a living will and a HIPAA form, because everybody we want to have the ability to talk to the doctor needs to be identified on that HIPAA form, or the doctor gets in serious trouble if he talks to them. So we always create a healthcare power of attorney and a living will that speaks to end-of-life issues and a HIPAA form as part of a living trust estate plan. Now, we do some other things that other law firms don't do. For every client, we will create a memorandum of tangible personal property. What we try to do is to make it as easy as possible for you to sit down with your ink pen and make a list of who it is you want to leave your tangible property to. I'm talking here about things like shotguns and jewelry, family heirlooms, the grandfather clock, those kind of things. We want to make it as easy as possible to dispose of that. And so we will include in your living trust document language that says that if you create a handwritten memorandum, then your trustee is obligated to carry out the terms of that handwritten memorandum. And so to make it easy and convenient, we include that in our portfolio of documents for our clients. We also include a document that makes it easy and convenient for you to specify your memorial instructions. This is something that nobody wants to think about, but we try to make it as easy as possible for you to sit down and spend a few minutes reflecting on what you would want your funeral to be like, where you want it to be conducted, how you want to be buried, answer all those questions so that other people don't have to make those decisions if something should happen to you. And then we also provide a document that we call a legacy organizer. If you think about it for a minute, if something happened to you, you probably have a lot of things there that other people don't know about, or at least they may know about them, but it would be really difficult to gain access to it. For example, a computer. In the legacy organizer, we provide a way that you can leave all your passwords to all the various accounts you have, so that you can entrust this legacy organizer to people that you care about, so that if something happens to you, they at least have the ability to get into your computer without having to go hire a computer consultant to figure out how to crack the code on it. We also include a place there for you to leave all of your frequent flyer miles, account numbers, all things like that, because these are things that are quite often overlooked. And so this legacy organizer is something we developed that a lot of our clients really feel good about. So anyway, that's just a quick summary of the documents that are included in a basic living trust estate plan that we create here at our law firm.